So what are the rules for when an employer wants to deploy technologies in the workplace that have an impact on employee privacy? I'm thinking about things like cameras, monitoring the use of building passes, or installing telematics in company vehicles. We have a whole mess of laws and a lot of gaps here in Canada, but there are some common principles at play. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. I should note that my firm generally represents employers in matters like these. Canada has a patchwork of privacy laws as far as workplaces are concerned. I have an entire video on this channel, which I'll link to below about that. Provincial governments have exclusive jurisdiction over most workplaces since they are considered to be provincially regulated. Some workplaces, however, are federally regulated, like airlines, banks, telecommunications companies. Some workplaces are in the public sector, such as governments, school boards, public universities, and crown corporations. Most workplaces, however, are private sector. All of them are regulated differently as far as privacy law is concerned, and we do have a lot of gaps. For provincially regulated private sector workers, there are laws in British Columbia, Alberta, and Quebec. Federally regulated private sector workers are subject to the federal privacy law, the Personal Information Protection and Electronic Documents Act. Public sector, meaning government and their workers, are subject to public sector privacy laws. For everyone else, there's nothing. I will note that Ontario has a quirky thing that I'll talk about later, and Quebec has a very different regime, which may end up as its own video. In British Columbia, Alberta, and the federally regulated private sector, employers can collect employee personal information without consent where it is reasonable or necessary. Here's the provision from PIPEDA related to federal works undertakings or businesses. They can collect, use, and disclose personal information about an employee where it is necessary, and the employer has given notice to the employee of the collection, use, and/or disclosure. The equivalent provision in British Columbia says reasonable instead of necessary. So how does this play out in reality? One of the first cases to grapple with this under our federal privacy law was a federal court case called Eastman and Canadian Pacific Railway. This was actually before Section 7.3 was added to PIPEDA, but the test employed is still the same, and this test is often used across legal regimes. In December 2001, Canadian Pacific Railway installed 6 digital video surveillance cameras in their maintenance yard located in Scarborough, Ontario. The mechanical facility at the Toronto yard is the site of CP's diesel and car repair shops. On January 17, 2002, Erwin Eastman, the applicant, who is a CP employee in the diesel shop, filed a complaint with the Office of the Privacy Commissioner of Canada pursuant to PIPEDA. In his investigation, the Privacy Commissioner used a 4-part test and determined that CP had violated PIPEDA by installing the cameras. This 4-part test requires asking, is the measure demonstrably necessary to meet a specific need? Is it likely to be effective in meeting that need? Is the loss of privacy proportional to the benefit gained? And is there a less privacy-invasive way of achieving the same end? So when this came before the federal court, the court used the same 4-part test and concluded that it was reasonable in the circumstances for CP to install the cameras. First, the court noted the cameras were not surreptitious or hidden. There were signs, and employees were made aware of them. The cameras were not focused on employees. They were not used to monitor employee performance. The recordings would be kept only briefly under lock and key and would only be used by managers and the police if there was a reported incident to investigate. This Eastman case is just one example of applying the 4-part test, which is generally recognized here in Canada as the appropriate framework for determining whether any sort of potentially intrusive measure is reasonable. This test has been used by privacy commissioners, applying both public and private sector laws, and by arbitrators in the context of grievances in unionized workplaces. Another recent example is from an arbitration in Alberta where the union grieved the presence of security cameras in the employee lunchroom. The size and the nature of the facility were such that there was no alternative place for employees to go on their breaks. The employer in that case had a written policy that set out parameters around the deployment of CCTV cameras, and when the ones in the lunchroom were installed, it was clearly communicated and documented what those cameras were to be used for. The intended purpose of these cameras are for incidents resulting from security, loss prevention, safety issues, and concerns, or a reactive approach like slip and falls, physical confrontations, potential thefts, etc. The security cameras are not intended for fishing expeditions, whereby management, supervisory personnel, are using the cameras to seek out performance issues, policy violations, etc. And importantly, the cameras were not monitored in real time and access was strictly controlled and limited to legitimate investigations. The arbitrator found in the totality of the circumstances that their deployment in the lunchroom was reasonable, and most of it turned on the fact that the company had a policy. The only remedial step required by the arbitrator was better communication to the employees about these policies. And here I paraphrase. The employer shall make known to its employees by way of a sign placed in the lunchroom as well as inclusion of statements in policies and handbooks that deal with the following. A. Referencing the existence of the surveillance cameras. B. Explaining that the video recordings are not accessible remotely. C. Explaining that the video recordings are not accessible except by limited personnel. D. Stating that they are accessed only when there has been an incident that necessitates their review as part of an investigation. And E. Explaining that the video recordings are deleted by overwriting the data after no more than 6 months from when they are made, unless they are preserved as evidence in the course of an investigation. All of this should highlight the importance of having a good policy and documenting for every measure the rationale using the 4-part test. You need to ask, is the measure demonstrably necessary to meet a specific need? Really, what is the purpose? How important is that need? Is it a real concrete need or something that could be called speculative? Have there been incidents in the past? Then you need to ask, is it likely to be effective in meeting that need? Will the intrusive measure actually prevent the thing you're trying to prevent, or will it legitimately help you investigate a serious issue after the fact? If it will not be effective, it simply should not be deployed. The next step is considering the balance between effectiveness and privacy. It asks, is the loss of privacy proportional to the benefit gained? What sort of impact does it have on privacy? What are the privacy interests at play? How intrusive is it? Are they cameras outside the buildings or cameras in a working area? What's the trade-off here? And finally, you have to ask, is there a less privacy-invasive way of achieving the same end? If the legitimate interests of the employer can be met by less privacy-intrusive measures, those need to be adopted. And remember, you can fine-tune things. Like the Alberta arbitration decision, it was less privacy-intrusive because the cameras were not monitored in real time, but recordings would be referred to only if an incident arose. All of this decision-making needs to be documented by the employer. The process of documenting is in and of itself valuable since it will force you to methodically consider the 4-part test and to canvass all the alternatives. And having that documentation will be critical if the measures are questioned after the fact. And speaking of the importance of documentation, Ontario recently amended its Employment Standards Act to require employers that employ 25 or more employees on January 1 of any year to have a written policy on the electronic monitoring of employees in place. The policy must state whether or not the employer electronically monitors employees. And if the employer does, the policy must include A, a description of how and in what circumstances the employer may electronically monitor employees. B, the purposes for which the information obtained through electronic monitoring may be used by the employer. C, the date the policy was prepared. D, the date any changes were made to the policy. An employer must, within the specified timeframes, provide a copy of the written policy to all of its employees. It doesn't say what has to be in the practices of the employer, they just have to be documented and communicated. And just one final note, in certain cases, employers may be able to use investigation techniques without the knowledge or consent of the employees. Any employer would be wise to get specific legal advice before considering that. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for any other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.